Welcome back, everyone. It's the lawyer you know, and we're talking more Ahmaud Arbery today, closing arguments. We'll talk about some of the other arguments that the lawyers got in again. We'll talk about another motion for mistrial by one of the defense lawyers. We'll talk about some of the rulings the judge made, and we'll talk about how the jury is going to be deliberating somewhere other than where they've been meeting throughout the trial. So thanks for jumping in with us today. At the end of the video, we'll talk a little bit about how long we expect them to deliberate. Again, what we expect the verdicts to be, how we think maybe it's not a slam dunk guilty across the board. As always, I'm going to answer your questions that you get in the chat. Make sure you subscribe if you haven't already. Like the video if you want more Ahmaud Arbery. So let's jump right into the closing arguments. State gets to go first. They have the burden of proof. So it shouldn't be surprising at this point. Anybody that follows this channel, they should know. Hello, Star Bell and RSK guilty. And the Lucky and DFID and understanding the scripture. Everybody jumping in here saying hi, angel eyes. Thanks everybody for jumping on. So the state opened up with one of the most annoying statements that any prosecutor can say. And they do it all the time, and they try to do it all the time. And a lot of defense attorneys object to it, us included. And depending on the judge, we can affect what it is they say when they start any speech, opening statement or closing argument. And I thought the prosecutor did a great job with her closing. We'll start with that. But I despise this line. I represent the people of the state of Georgia and the people of this county. And right now, you are this county. That's what she said to the jury. The reason I hate that so much, you may think it's not that big of a deal, is it literally is inferring that the state attorney is on the same side as the jury. And we're all here against the defendant, which is blatantly false. They don't represent those jurors. They don't represent you. They don't represent me. They don't do what I want them to do lots of times. They are not my lawyer. They represent the government of the state of Florida. And that's sometimes what we get them to say. It all depends on the judge, on how much they're going to tone down what they let the state say, because they love to say they represent the people of the state that they work in. And it's so frustrating as a defense attorney because trial and in the courtroom, it's supposed to be a level playing ground, even playing field. And the facts and the law are supposed to hold the day. So when they do stuff like that and try to tilt it, I have a problem with that as a defense attorney. So we'll start with that. Not that big of a deal maybe to some of you, but it makes me cringe. And we know it's coming. So before trial, we will have a motion, have arguments on that beforehand so that the state knows what they can and can't say. Citizen's arrest, she blows that out of the water in her first 2 minutes of closing, explaining what we already knew, going through the jury instruction, saying how there's no evidence that a crime was committed within their presence or immediately within their knowledge. She talks about how the fact that the citizen's arrest was never even mentioned when all these defendants were giving statements to the police. They didn't say, oh, we were out there trying to make a citizen's arrest. They never said any of that. And she took some real shots at the defense lawyers, basically saying, you all came in here and you created this for trial, basically. Hold on one second. Let me hit this do not disturb here. Hopefully that helps. But yeah, so she comes out and just takes shots at the attorneys, basically said the slick lawyering in this case is here to try to trick you and divert your attention from the common sense. And she hammered in on common sense throughout her closing. She talked about the credibility of witnesses, which we always talk about on here. We go through those jury instructions that I use a lot in my closing arguments, and credibility of witnesses is one that we talk about all the time. You can totally dismiss something that certain witnesses say if you don't find them believable. You can give more credence to one witness over another. You as the jury get to make that decision and determine what evidence and facts you believe and hold strongly to and which ones you don't. So she talked about that. I talked about deadly force being the last result and how you can't claim self-defense when you're the one that drives up, tries to hit somebody with a pickup truck, corners them like a rat, the quote she kept using, pulls guns on them, shoots them. You can't then claim self-defense. That is not how it works. You can't chase somebody, create the problem, corner them, pull a gun, and then say, oh, it was self-defense when they tried to defend themselves. So I thought she did a good job talking about common sense. She also went through all of the elements of all the crimes, the attempt to commit the felony of false imprisonment, the ag assault with the pickup truck, the ag assault with the 12-gauge shotgun, felony murder, which we've talked about here before. I talked about it with a lot of my lawyer friends. I hate that statute. That now in this case, it may apply decently well, but in certain cases, as horrible as it is to commit a felony. Okay, I'm not dismissing any felony that anybody commits, but the felony murder rule, it can be, a drug deal where somebody dies. It can be, even a robbery or burglary of a liquor store or a home, and somebody dies because of a heart attack, or somebody dies because they fall down the stairs, or, whatever happens, and somebody dies and you go to prison for life. Now, a lot of you will say, well, you shouldn't have been committing the crime in the first place. And I agree. You shouldn't commit crimes, especially heinous crimes like that, especially felonies, which are the more serious crimes. But our sentencing guidelines and our criminal justice system has penalties for those felonies. So if you commit a burglary, you get X amount of years in prison, depending on what state you're in. Not life or death in certain states. Yet when a murder occurs or somebody dies, you could then get life or death, even without any intent to kill or commit that heinous of a crime. So why then does it apply to felony murder? That's the issue with me. I understand why intellectually. I just don't think I agree with it. So we can talk about that some more as we go, the felony murder crimes. Then she talked about being a party to the crime, which I think was maybe her weakest argument. She basically says, if you cooperate at all, she gave some quotes, get your shotgun and let's get that guy. And then she said making a video of the murder makes you just as guilty as the murderer, basically, which I don't necessarily agree with. And we'll talk a little bit more about that. Travis's defense lawyer, before he starts his argument, there's a lot of argumentation on what he can provide in his closing argument. If you guys are interested in the arguments they made before his closing argument, how that works, and whether or not we have to show the opposite side our presentation, whether it's PowerPoint, whether it's a poster board, whether it's paper, I have a question for you guys, and I want you to answer this in the chat. If any of you watched this and you saw a PowerPoint, you saw paper being used, you saw a poster board, you saw some blow-up pictures, you saw some videos, what do you think is the most effective evidence and way to portray it to you as future jurors? Because that helps me. Try a lot of cases. I mostly have presentation software. It's not old school PowerPoint, but it allows me to manipulate the pictures a little bit. When I say manipulate, I mean zoom in or draw on the picture or crop it right there on the spot as I'm talking to them. As I'm talking to the jury, I can pull out of medical records certain paragraphs and blow them up as a call out as I'm going. That's the presentation software I use. It's kind of high tech. Some lawyers say that's bad and jurors don't like that. And they make it seem like it's going over their head or you're talking down to them. So I would like your opinion. That helps me out as a trial lawyer. You as future jurors, what do you prefer? Do you like a combination of all of them? Do you like PowerPoint? Do you like postboard? Are you old school, new school, whatever? So let me know in the comments because I'm very interested. I'm very interested in what you all think about that. Sorry. So, all right, the defense talks about how, Travis has all of this training and how he was an officer in the Coast Guard, his duty to follow the law. The neighbors all felt like there was a scary situation because there were these, lurkers wandering around. And they thought he had a gun, and people have had guns before, and they think he's been armed before. And what's he doing there? He shouldn't have been there in the first place. And he's running away. He's not just out for a jog. Now, the best argument the defense has is in the video. Ahmaud Arbery is reaching for the gun, puts his hands on the gun, is clearly punching Travis, is clearly fighting with him at that point. Problem for them is he is the one that brought the gun to this situation and chased after Ahmaud Arbery with a truck, trying to make a citizen's arrest instead of waiting for law enforcement. This was not a chaotic situation until they arrived, yet he's claiming self-defense, which I think if I was a juror looking at this from a reasonable person standard, I would not think was reasonable. And he ended with some quote of, We have carried him to the surface for you. Now it's your turn. Will you do as he has done for others? Will you reach out your hand to Travis McMichael and pull him out of these waters? Literally asking for sympathy for the jury because he has saved people in the Coast Guard. I would have objected to that if I was the state. I don't think she did, but I can't remember. Greg McMichael's attorney, I actually thought she did a pretty good job. But this is where the kind of subtle pot shots happen between co-defendants. She said multiple times, he did not pull the trigger. He may have had his gun. He may have said some things. He may have wanted to go make the citizen's arrest, but he basically did what you're supposed to do. Go there, try to stop him. He even says, let's hold him and wait till the police come. He did not pull this trigger, which I think is important, but damning and not great for his son, Travis. She also took the philosophy and the argument of attacking the victim. Sometimes it works, sometimes it doesn't. You tell me if you thought it was effective. She said he wasn't a looky-loo. He wasn't a victim. He was a criminal, basically. The long, dirty toenails or something. He may have had some promise as a youth, but that's long gone. He's basically a criminal. She attacked him. She also had a lot of sarcasm throughout her closing. And this is another question I have for you. The sarcasm some people think is offensive and you shouldn't be sarcastic even when not being rude to a person or a juror, but something like, oh, the state's going to say this, give me a break. That can't be true. Oh, they're really going to argue that type of sarcasm when lawyers make it. I'm generally sarcastic, so I have to guard against doing that when I'm arguing to a jury. But what do you guys think? Do you think sarcasm would sometimes work because it has the effect it's supposed to have, or do you think it's offensive or not meant for a courtroom? That's another question we trial lawyers wrestle with, and we get in our own head, and we have a echo chamber sometimes. We all try cases and we talk about our strategies, but I like hearing from people that would be potential jurors and don't necessarily live in the courtroom, but come in for one time, and we give them a snapshot of the case, and they have to make a decision, or you have to make a decision. What do you think about lawyers using sarcasm when describing other lawyers' arguments? All right. Lastly, the defense attorney for Roddie Bryan, who most people in the public have not cared for throughout this trial. I feel like he made some reasonable arguments, and I actually think the best chance at a not guilty for any of the charges are the ones that apply to Roddie Bryan. He said this case wouldn't have existed unless Roddie Bryan turned over the camera to law enforcement, gave his statements to law enforcement. All he did was drive up on it and document it. He didn't bring any guns. If anybody did what you're supposed to do in a citizen's arrest, if you listen to the prosecution, Roddie Bryan did it. He showed up with his truck, documenting it to give it to police, and he was going to wait for police. Nothing he could have done to prevent this tragedy. He doesn't need to be sitting here. He's totally superfluous to this trial. I think that he made some arguments that if I was a juror, I would say, even if I thought it was murder, if I thought it was a false imprisonment, if I thought this was felony murder, whatever I thought of, especially Travis, it kind of trickles down then to Greg maybe, and then to Roddie. I don't think I can make him an accomplice to this murder, but you guys, what would you do as jurors? He said, again, more shots at the other, the co-defendants. Didn't bring his gun, didn't shoot anybody, didn't pull the trigger, was not a vigilante. It's funny sometimes when it benefits a defendant for you to call them stupid, but basically that's what he did to his client. He said, not the smartest man in the room, didn't, cook this up, was there without a lawyer, spilling his guts to law enforcement because he was just trying to do the right thing and make things right. And I thought he did a good job saying, because of his video, we can get justice here, whatever justice you all as a jury decide that might be. Interesting arguments. He also talked about he didn't make a claim when his trailer was stolen because it's just stuff. A little wink to life over property. And now when you lose something, it's not worth taking someone's life. But he did something that we never do as civil lawyers. He testified for his client who didn't take the stand, basically. He said he said what they were thinking. He said what his client was thinking, who his client knew and didn't know before. And he didn't know Travis McMichael. He didn't know they were going to have guns. How do we know that? And the state objected. Facts, not evidence, Judge. He's basically testifying for his client. And he makes some little argument, but generally he agreed. And he was testifying for his client. The problem with that is, well, if that goes up on appeal, you could lose because you testified to facts, not evidence. Your client didn't take the stand. He waived the right to testify and get these facts and evidence. But what do we know about defense cases? Criminal defense lawyers have the most leeway of anybody because they can't go lose on appeal. That's a fact, and they know it. Sometimes things like this happens where he testifies to them. And, of course, a day would not go by if Roddie Bryan's lawyer did not ask for a mistrial because of someone standing outside the courtroom. This time it was the Black Panther Party that he asked for a mistrial. The judge denied it, but that did happen. So that's kind of where we ended for the day, except that there was some discussion about that party and some people outside that were now marching around the courthouse. Now, if I was the prosecutor, if I were some of the people they're supporting, I would try to tell them, don't do anything that's going to cause a mistrial. We think we're going to win here. They did that, and the judge thought it was significant enough that he's going to move the jury to an internal room to meet and deliberate. Now, the defense attorney for Travis McMichael said, well, Judge, is that going to make them think, well, they should be scared? We can't even have a window now. We have to be in an internal room. And that's something to consider. And the judge said if he's got to have some dialogue with the jury, he will. But right now, he doesn't think of that. So that's basically the breakdown of the jury. Of the closings, I didn't see the state come up for her second close or rebuttal. I'm not sure if that happened, if they're waiting for tomorrow for that to happen. I don't think he charged the jury. I wasn't able to watch the very end of closing, so I don't know if that happened or not, but she does have the opportunity to come around for second close. All right, I'm going to get into the chat now. We're going to answer some questions, see what you guys want to hear about. A lot of people saying hello. Thank you, everybody, for joining us as always. Yes, hit the like button. Eric McDowell asking, I'm curious, will the state give another closing tomorrow? So each side does not get more than one, just the state does. They have the burden. They get to go first and last. New Chris, happy holidays to you and your family. Yes, happy Thanksgiving. We're just a couple days away from that. We'll probably have some more videos this week. But thank you, everybody, for spending time this Thanksgiving week with us. We'll probably do some lives on Friday, maybe even Thursday if something happens. But we'll be with you. But happy Thanksgiving to everybody that joins in on our page, and thank you so much. One recurring phrase the DA and defense attorneys kept fighting about was the charging conference was initial aggressor. Explain that to us. So this is more of a common sense argument. Who was the initial aggressor? Who started this altercation? Who started this problem? So if they pull up and, just say I get out of the car and I say, hey, buddy, just stay here. We've called the cops. We know you've been trespassing or burglarizing these properties. Please stay here. And then Ahmaud Arbery pulls a gun or punches them or starts a fight. Then Ahmaud Arbery could potentially be the initial aggressor. But when you jump out of the car yelling stuff like blow his head off, stop there, I'm going to blow your head off, go get him, and you pull out a shotgun, then you're probably the initial aggressor based on common sense. But that's something the jury is going to have to determine. That's what they're talking about for initial aggressor. Who was the initial person that make an aggressive action, basically. All right, let's see what else we got. RS Guilty, yes. It's lawyeryouknow@gmail.com. That is the email address I have for you to reach out if you have any real questions that are potentially legal advice. I can't give legal advice over YouTube because of how the Florida bar works. But if we have a private email or call, I'm happy to help you out if you have a case that I can work. Oh, here it is. Understanding the scripture, yes. I think she presented a good closing argument. I think she did a good summation in the beginning, a breakdown of each of the charges. She went through certain jury instructions. You don't want to go through all of them and put them to sleep, but you want to make sure you get into the weeds enough. And that's something us trial lawyers, it's hard for us because we balancing getting into the weeds but not boring the jury, summarizing the case and making it simplified for the jury, but not going too surface level. It's all a balance that we stress over before we give these arguments. And I think she did a good job personally. No, I'm saying her closing argument I thought was good. Hello, Brianna. All right, video and PowerPoint. Here we're getting into what you'd like as part of a presentation of a closing argument, all of them. So this is usually what you try to do. You try to use as many different things as you can. Like we have our presentation, then when I'm going through the jury verdict form, I use the Elmo or I use a big poster board. I check off, rule in favor of our client or rule not guilty or whatever it may be for the jury's vote. But yeah, we try to use different ones. We try to use poster boards, pictures, presentation. You got to do it smoothly, baby. You got to you got to be smooth when you're trying these cases. You don't want to fumble around. If something's going wrong with technology, you say something like, technology, isn't it always fun? And you keep talking while somebody else is fixing that for you. Video and PowerPoint, video and concise PowerPoint. Yes, you don't want to do the big blocks of words. She had some of that. I like shapes and arrows where you take people's eyes. You start here, you take an arrow so their eyes move from this phrase to this picture or whatever it may be. I like timelines with pictures on the timelines, treatment records, or facts that happen on a timeline, I think are really helpful for people as well. Picking on a juror is wrong. Yeah, agree with that. Minimal visual material, speak from memory. Okay. Yeah, reading something never goes over well. Usually an outline that jogs our memory, make sure we hit the big points, but expand on them from what we remember from the trial. PowerPoint. I'm so beat. Last week was brutal. Today was already brutal because I pushed so much for today, and we're squeezing everything in a short week, just a couple days this week. Thanks for noticing. I'm new school. PowerPoint that lays out the evidence. Evidence on the screen you can zoom in on, highlight, no paper overhead projections. Good. But as you can tell, and as everybody can tell, people have different preferences. So we try to hit as many jurors, and some jurors like visually learning, audibly learning, learning by doing. So we have to try to, bring the jurors along the journey with us. Lana likes demonstratives, but would have to see how it's delivered, of course. Yep, the body language and delivery is everything. Michael Buck, as a former jurist and a potential jurist again, I prefer an organized presentation with video, PowerPoint, anything that clearly presents the information. Yep, organization is key. You've got to have a beginning, middle, and end. It can't be all over the place, and that's sometimes where lawyers struggle, in my opinion, when I watch them. I like to have it organized so you can go along with me. Even sometimes you know what's coming. So it confirms what you think I'm going to say later because we just sat through the same presentation of evidence. DFID said Greg's attorney did well. If you were a jury, you would have bought what they were selling. It sounded reasonable. Melistasi, it's offensive. I think you're talking about sarcasm there. Yeah, the lucky no socks and dirty toenails was brought out to prove he wasn't out for a jog exercising. I think you're right. Kolodokov Andre. What do I think was about race in this case? So, besides the color of the skin. So yeah, okay, obviously that's part of it, but I think the bigger part of it is the fact that the judge said he thinks there was some racial discrimination in picking the jury. The lawyers have argued about race a lot in open court about who's outside. Black Panther Party, black pastors have been mentioned. Race has been mentioned left and right. So I do think there is a racial element of the case. I'm not saying it's fully based on race, but I definitely think there's a racial element of this case. Don't like sarcasm. Misty Rose said it comes off as showboating. I usually try to avoid it. Now, to me, I think it works. If somebody's sarcastic, it does make me think about something a certain way. But again, I'm not your average juror because I'm the one trying the case, and I'll never be on a jury most likely. So that's I'm taking your point, and that's usually how I've built my trial strategies, not to use sarcasm. Yeah, everybody's basically saying they don't think it's appropriate. You're not going to like me, Diana Rose. Starry says it depends. DFID on paper, Roddie's lawyer will look good. It's funny how different things look in the transcript. Lucky, you'd be surprised how common that is for lawyers to go with the "my client's too dumb to commit this crime" argument. Yes, Angel Eyes, they're all being tried together, although Roddie's lawyer, after the close of evidence, asked to sever his case, try his case separately, but the judge basically said it's untimely. Other people saying they feel sorry for Roddie, even if it's just a tiny bit. Yep, cut the sarcasm. You want them all to like you, even if it irks just one of them, that's undesirable. I agree with you, which is also why we try the different presentation ways. Roddie's probably the only one that could get a break. Potentially agree with that. And they do get a rebuttal tomorrow, Mira said. So that's interesting. So now she has all night to prepare again for a rebuttal. I also think we talked about the Rittenhouse case, how the judge may have been leaning toward the defense. This judge absolutely leans toward the prosecutor, which is more common. The prosecutor objected to the defense lawyer putting in his notes about what the testimony was after she just did a whole PowerPoint presentation about what she thinks the testimony is. That's a horrible objection. And the fact that the judge even heard argument on it was insane, in my opinion. That the defense lawyer is not allowed to put notes up there about what he's going to argue the evidence showed. That's horrible. I totally disagree with the judge even giving credence to that argument. And then the prosecutor's like, actually, judge, the state will allow that. They won't argue that. And the judge said, okay, you can let it in. So he waited until the state allowed it when the judge should have just said, no, that can absolutely come in. So I had a little bit of a problem with that. And that's the judge showing his hand that he clearly is leaning toward the state. State is using 2 hours starting at 8:30 tomorrow, they said. Wow. A lot of people tell me state will finish tomorrow. Thank you. So Michael Buck is talking about how you can track down specific suspicious people, and the initial aggressor is the criminal, and he's been on neighborhood watch. There are no laws that allow neighborhood watch to act as police officers. So I disagree with you there. You can't run up on people with guns and corner them and hold them at gunpoint, generally speaking. That's not how the law is written. Now, there can be a neighborhood watch who can even potentially detain people, who can call law enforcement, report to law enforcement, things like that. And especially if you see a person committing a crime, that's different than chasing somebody down the street. And you'll notice, so Ahmaud clearly made every attempt to not be detained. If you'll notice, and I agree with that, he was definitely trying to flee and not being detained. There's no fleeing and eluding neighborhood watch or fleeing and eluding a citizen's arrest. That is not a crime. Fleeing and eluding law enforcement is a crime. Yes, Mad Walls. I do want to get to this. How long do we think the jury will deliberate? So, depending on when the state finishes, I thought closings were going to end today. And my estimation would have been I think they were going to have a verdict by Thanksgiving. So, by the end of the day on Wednesday. I still think that's possible. I think by the end of the day on Wednesday, if I was going to bet, I think they're going to have a verdict. What do you guys think? Yeah, there's some disagreement going on in the chat about whether or not you'd stop if somebody came to detain you. Generally speaking, I'll tell you, I probably would not. If somebody just showed up next to me with a gun or with something else, I'm probably running. I'm getting out of there. I'm not letting some just random citizen arrest me, whether I've done anything wrong or not. Now, if it's a cop, I'm stopping every time. I'm cooperating, hands going up, whatever it is. That's the point of law enforcement. And it is not legal to pull your gun on someone, even if you have a carry concealed, if they're running down the street and you didn't see them commit a crime. That's actually an unlawful exhibition of a firearm. That's a crime in its own right. We've actually had clients that we feel pulled their gun for the right reason, potentially, and they still get convicted of unlawful exhibition of a firearm because you can't just pull your gun in a scary situation. We've got a road rage situation where somebody's pulled a gun and just waved it around so the person would leave, which they did, and then they called the cops and our client got arrested for unlawful exhibition of a firearm. So New Chris, yeah, you would think that the judge admitting that would make it an automatic mistrial, but he didn't. He said he's going to let the trial continue. And again, that's not something the state will be allowed to appeal if the defense wins this case. Now, I don't think anybody's worried about the defense appealing the fact that there's only one black juror. So if the state wins, I don't think it's going to be, I think he thinks it's discrimination in favor of the defense is what I think the judge thinks. I agree. Bill Tower Biker, I think Roddie's attorney inferred that the other two guys are guilty here. Not necessarily, he didn't come out and say it, but he's saying they might be guilty, but my guy's not. That's more what he said than they are guilty. Sue Nichols loves sarcasm as long as it's smart. Rittenhouse prosecutor failed when he stated that I guess a skateboard is a weapon. Shouldn't buy our kids skateboards. Yeah, that was dumb. All hail King Rose. Judges are going to lean where they're going to lean on some cases. I don't think it's dispositive. I don't think a case always ends up like that. I've had a judge that leans with me on some cases and I lost. I've had judges that lean against me and I've won, and vice versa. Verdict by Thursday, people are saying, some people saying they think they come back even quicker. Are they being sequestered? Not at this point, not that I've seen. 2 hours, Haley Has Hope says they think. You think innocent or guilty? I think Travis McMichael is going to get convicted. I'm starting to lean toward Roddie getting not guilty verdict, and then I think Greg McMichael probably guilty as well. That would be my lean at this point. You guys let me know what you think. Thank you, Sylvia. Mira, I definitely think it's an advantage for the prosecutor to be able to come back tomorrow for 2 hours and get this last chance to convince this jury of what she thinks the case is about. Sorry, my hair is just all over the place. And give the jury what she thinks this case is about, how this should come down, have the final word. She's going to go through the verdict form with them. At least I think she will. it's definitely a huge advantage. Slider, how do you think the prosecutor who's not Southern played with the jury compared to the 3 Southern defense lawyers? So we talk about this all the time. You go to certain pockets of certain areas, certain jurors are more like certain people, and they like certain people. They like certain accents and certain mannerisms and the different words different types of people use. There's all different dialects across all different, whether you're Southern, Northern, whatever your culture may be. And people generally do like certain cadences and things. So we'll see. I don't think it's been a problem in this case, but we've gone up, a county up the road, and they look at me like, what are you doing here? And sometimes we talk about that and think about that and what the best way is to deal with that. But try to pick a fair and impartial juror that's not going to hold any of that against us, because we speak a little differently, maybe older or younger, maybe white, black, Asian, whatever it may be. And we try to just present the case and not make the jury decide based on that, because they're not supposed to. How does the state handle sentencing? The judge will determine the sentence. I haven't followed this case closely enough because a lot of other things have been going on. I don't even know if they're seeking the death penalty. If there is death penalty, usually the jury decides, but I think that the judge is deciding the sentence in this case. Matthew Presley, agree the first 2 are guilty. Roddie, I'm not sure about. Could see his go either way. Yeah, he definitely threw the McMichaels under the bus. Roddie helped with the entrapment. I think you mean the false imprisonment. See, I don't know. That's the type of stuff, the false imprisonment charges, especially for Roddie and where he came from. To me, if I was a juror and they're going to make these citizens arrest arguments or whatever, or what should they have done if they think there's a criminal in their neighborhood and they've had issues with it before, if these guys really just pulled camera phones and followed Ahmaud Arbery in their truck and tried to document it for law enforcement to come and arrest him, I don't think personally I would have had a problem with that. Yeah, karma, God, or whatever you believe in. It's always a weird way to end a closing. Randall wants them to take at least a week, I assume, to make sure they really dig into all the different charges, because there are a lot of, if they come back with a quick guilty, they barely read anything and they just bought what the state was selling. All 3 guilty. So we want so that's back-to-back comments, shows me you're pretty well thought out. You want them to take at least a week, but you think all 3 are guilty. And Michael Buck, not surprising, thinks not guilty for all 3. And that's the point, is we could have these 2 guys, Michael Buck and Randall Design, on the same jury. And we'd see, how it kind of played out. So John Crypto keeps asking, when did they point their guns at him when they got out of the car? So are you saying like before? I'm not sure if it's clear in the video, because there is part of it that's off the video. I think as he's getting out of the pickup truck, he's got the gun pointed at him. But I assume you're trying to make the correlation to Rittenhouse, where maybe he didn't point the gun at him until he lunged at him or tried to grab the gun. I'm not sure how that exactly came out in trial. Melistasi, if you were one of the defense lawyers, what would you do differently? So I definitely would not just concede half of my defense. That's the biggest mistake they made, in my opinion. And I would have really, really focused on the self-defense, similar to, I would have played it more similarly to how Kyle Rittenhouse's lawyer did, maybe getting an expert on how all this stuff happens in a split second. I would have gotten into as much as I could the crimes that that were happening in the neighborhood, which it seems like they got into. I really don't think they had a ton. I also, if I was representing Roddie, I definitely would have severed the case. Chuck Summers, yes, is done for the day. Yeah, so no death penalty. Thank you, Cynthia. So if it's life or less, then it's going to be the judge making the decision. You're not going to like me. Do you think they'll get stiffer penalties if convicted because of the media attention? No. It seems like this judge was going to give some pretty stiff penalties no matter the media attention. So Matthew Presley, the problem with the prejudice in the jury is the idea of preemptory strikes in our system makes it way easier to do that. So you cannot use a preemptory strike for race. And the other side can actually force you to come up with a race neutral reason as to why you're striking a juror. So that is something we have in the law. Yeah, most places entrapment is false imprisonment. Usually entrapment is used in a different word. Entrapment is used as a defense where the government entraps you into making a defense, basically tricks you and forces you into committing a crime. So that's usually how entrapment is used legally. False imprisonment is when you kidnap somebody and hold them in a room. That's false imprisonment. Cat without a hat, lawyer, I don't know actually. Well, now you do. Michael Buck, deliberation would be very interesting to say the least. I agree with you there. TA, no, the jury's not deliberating yet. So DFID, we've actually had this happen in a case. What do you think about the lawyers saying the juror was sleeping? The judge said he never saw it. This has happened in cases. We've gotten jurors thrown off for us thinking they slept. The prosecutor disagreed with us. The judge said they didn't see it. We made a motion and we ended up arguing that it did in fact get the juror thrown off. But this is the issue with asking for a mistrial every time you disagree with something the judge does. Sometimes it's like crying wolf, and the judge may show their hand that they don't necessarily believe what you're saying, which is also why as a lawyer, your reputation is everything. And usually if I say something like that in trial, a judge is going to believe it because I'm not trying to pull punches and do underhanded things and be slimy. If you're above board and you're honest and the judge knows that, and a lot of these judges, we know each other personally too, so they know your personal life, how you are, it can go a long way when you're trying these cases. Johnny Lawson, yes, it's possible they come back with a verdict for one or two of the defendants and not the other. They could get a hung jury on one. Yes, it's possible Roddie could be not guilty and the other two guilty. Yes, I didn't see what the Mad Walls said about Michael Buck, but Michael Buck is not making it personal. He's voicing his opinion. You can disagree with it, not disagree with it. He can debate it with you in the chat, but let's not get personal. Let's not make this into what's so horrible in our world today. We can have these discussions. Whether you like it or not, people have thoughts and feelings that you don't agree with. We can talk about them. We can discuss them. We can see how people feel. We can disagree. We can even end it and say, let's just agree to disagree. Let's not make it nasty. Sweet PV, from what you've seen, do you think they deserve the charges? So not even just the conviction, but the charges? Yes, I think there's enough to charge. At least two of the three. I don't know if I was a prosecutor if I would have charged Roddie with anything. Did the prosecution offer a plea deal? I've been hearing the defense has asked for a plea deal and the prosecution's not offering it, but that's coming from Arbery's mom, I believe. I'm not sure. And a dude at Audit Giant. Moral of the story, never talk to the police. I agree with this. I mean, generally speaking, you can get yourself in trouble by talking to the police, by giving them videos, by turning over your phone. You should always talk to a lawyer before you talk to law enforcement, because you could be doing something you think is fine and you get caught up in the whirlwind and all of a sudden you're on trial for murder. I agree with this. John Crypto, I have to disagree with you there. Yelling stop or I'm going to blow your effing head off is threatening, especially when you actually have a gun. There's a big difference. Can you follow through on that threat? There's a big difference in somebody saying I'm going to blow your head off if they don't have a gun. So Arminius, well, cases like this grab our attention. Epstein's right hand. Ghislaine Maxwell is starting, and most people have no idea. One of the problems, it's federal court. We're not going to be able to get to watch it, but I think we are going to do some coverage on that. So stick around. If you're not a subscriber, make sure you subscribe. And anybody you know that you talk about that case with, make sure they come to our channel, get in the chat so we can talk about it. So Chuck Summers, will the jurors sleep through deliberations? No, they break each day. They go home. They're told not to talk about anybody, not to look up any coverage, talk to anybody about the case or look up any coverage, and they come back the next day like a job. Sweet PV per. If you get a juror off, doesn't that turn that juror against you and maybe some other jurors against you? So usually this stuff is talked about outside the presence of the jury, so the jury doesn't know which lawyer wanted the juror off or even the judge. And usually the judge will take the blame for stuff like this as to not prejudice the jury against the lawyer. And usually, I mean, if the juror doesn't like you, that's off. You don't care because they're off the case, but you don't want the rest of the jury not to like you. Interesting. Carrie can't be on a jury because she has narcolepsy. Yes, that would be a legitimate reason to get off a jury. Jesse Levitt, how much of this case is about is fact-based or law-based, whether it's about what he did or if the law privileges them to it? So cases like this, Rittenhouse in this case where you're dealing with self-defense and different charges, it's facts and law married together. And that's what the lawyers have the job of explaining to the jury how to marry those two together properly. All right, probably about 5 minutes left. I'm getting tired. I've got a Friendsgiving tonight that I've got to get to. Let's see here. Zach, sarcasm is super stupid and funny to me whenever I see lawyers doing it. Do you review your court work to critique yourself and improve? Yes, and there's different ways to do it. I actually ask judges sometimes, and we can get a conference call with all the lawyers, talk about how they think we did. We'll ask jurors if they're willing to talk to us in state court, federal court. The judges don't allow the jurors to talk to us afterwards. So I'll talk to jurors a lot. I've had jurors ask me for my card after cases, which is always a good compliment and funny. I try to get as much feedback as I can. I order transcripts sometimes for portions of the case if I thought they went well or if they thought they went poorly, to see how I could do it differently. So yes, absolutely. John Crypto, there is evidence and testimony that they said, stop or I'll blow your head off. Greg McMichael said that. So Molly Coyote Fire, why did no one get charged right away? There's a lot of background to this, but the initial prosecutor who didn't charge them is actually indicted on charges of her own. Do I think the jury should have been sequestered? Probably not. I don't think it's necessary for this case. But if they would have, jurors would hate me as a judge because I would always err on the side of sequestering jurors. I just don't, as somebody who grew up in the technology age, which most of these judges didn't, it is about impossible to keep yourself shielded off from any outside forces or reactions or talk about the cases like this. Some states do not allow broadcasting. Yes, I'm not sure which ones though. Chuck Summers, awesome. Always love new subscribers. If you're a new subscriber, post in the chat. Love having you. It's so fun to get diverse conversations going and chats and questions. That's what I love about this. And everyone views a potential juror, so I learn how to be a better trial lawyer by talking to you. That's what this channel is about. I'm not ever going to be a full-time YouTuber or YouTube lawyers. There are some that are awesome at doing that, and they're able to take so much more time to watch every second of these trials and read transcripts, and they do an awesome job at what they do. I'm just never going to be that personally because I love being a lawyer, doing trial work, negotiating settlements, negotiating deals. I love doing stuff like that. But I love talking to all of you guys on here, however many of you can join. Well, we've got schizophrenia, narcolepsy in here, all sorts of people with legitimate medical reasons why they can't be on a jury. Epic fails. Do you think the jury should have been sequestered? I don't think based on how they're sequestering juries in the case law, it was a necessary have to. I probably would have if I was the judge. Beautiful one. Are health issues such as strokes with partial paralysis? The judge and the lawyers would ask you, they would say, do you think you can sit here, pay attention without any issues? And if you said no because of my physical impairment, then you'd be let off if it's you or someone you know. Do you think the court system is a game? I wouldn't categorize it as a game fully. I think there are some games played within it, but I wouldn't say it's a game overall. Cat with without a hat. I practice in Florida, so all over the state. We actually have cases all over the country. We've got cases in North Carolina, Utah, Texas, Ohio, New Jersey. So we have cases in Minnesota. We have cases all over, but I'm based in Florida, barred in Florida. I practice mostly personal injury. Our firm does personal injury, car accidents, wrongful death, slip and falls, trucking accidents, nursing home negligence, and criminal defense. Nate and Mew, yes, we do criminal defense here too. My dad was actually the chief of the criminal division in the federal court in Tampa, the U.S. Attorney's Office. He was the head U.S. attorney over all the criminal cases. What was sealed regarding the jury? I don't know. I know he sealed 7 through 12 or something like that. I don't know exactly what was sealed. Depends on the age of jurors. I prefer high tech. A rigged game, as somebody who's been in it and beat the odds in David Goliath versus cases, I can tell you it's not rigged. And I think it's slanted in favor of certain parties and government agencies and things like that, but it's not a totally rigged game, in my opinion. Some people saying they think all juries in high-profile cases should be sequestered. It's hard because it takes a lot of time, money, and resources. Yes, Mira, it's really expensive and it's miserable for the jurors. And what we don't want to do in these cases is force them to rush and hurry, because you better believe if they're away from their families, they're not going to take a week to deliberate. They're probably going to get it done in one day. Thank you, Michael Buck. I appreciate that. And I appreciate you and everyone else that has an opinion in here that they're willing to just talk through. Drew, if you're talking about me, I agree with you. I do take it seriously. Epic fails. It seems impossible to believe they haven't logged in. Not just logged into Facebook, but like Google. This stuff's on the first page of Google with these cases sometimes. Bodie, I agree, and that's for sure what lawyers as officers of the court are supposed to do. Gregory Johnson, here's some free advice for everybody. Make sure you go get underinsured motorist coverage. If you don't know what it is, check your policy. It's cheap to add, $5 or $10 a month for the most part, and it covers you if you're hit in a car accident and the person that hits you doesn't have enough money or coverage to cover your injuries. You can cover yourself. Please go out and get uninsured motorist coverage. I actually have USAA as well. So yes, Gregory, I think as far as insurance companies go, I don't think any of them are on your side, but I do prefer USAA as my insurance of choice. Thank you, Eric. Makes it so fun. I mean, there are always going to be some people that are nasty and always have something to say. Got to let it roll off your back, and I always do that. But I love everybody in here that's fun and has a good time and uses it for what it is. We're just here talking about legal cases. DC, yes, for the most part, alternate jurors don't know they're alternate jurors. And in Kyle Rittenhouse's case, you better believe they didn't know they were alternate jurors because he was basically picking names out of a hat as to who would be the alternate. So yes, they're under the same exact rules every second until they're released. And even after they're released, sometimes if the judge says you're still under these rules, because we may have to call you back. Awesome, Bill Town Biker, paralegal. So white Mustang, why are prosecutors allowed to deceive the jury? Example, saying skateboard foot stumps is not to the head isn't a big deal. That's not really deceiving the jury. What they would call that is making an argument. It's a bad argument in my opinion, and it didn't win the day, but they're allowed to argue facts. Yes, you are a fun group, and you are definitely smart, keeping me on my toes. So I wouldn't say lawyers are lying. Okay, they're arguing some of these facts. Like somebody may think a kick to the head is a big deal. Somebody may think it's not. Seems obvious to me, and the jury can see through that a lot of times, which is important, and that's why we have a trial by jury. All right, we are 1 minute away from 1 hour, which is where I usually like to cut these unless the chat's going crazy with questions. But I appreciate you guys so much, as always, joining me. Make sure you subscribe if you haven't already. Let me know what cases you want to hear. A lot of people were reaching out about the cases, which we've talked about, and then also the lawyers that I've reached out to. Some of the ones that we got the most comments on of lawyers who want me to do a collaboration, talk about cases, which I love to do, whether I agree with them or not. And those lawyers are Rakita, Good Logic, and Nate the Lawyer were three of the biggest ones. So I have reached out to some of them, or I will be reaching out to them to see if we can do a collaboration. Hopefully that'll be something fun and something that we can do. But I really appreciate you guys as always for coming on and joining me. But for this time, as always, that's all we've got. Until the next time, we'll talk later this week.